So what are the legal issues? Well, clearly contract is really important. Now, what does the underlying T's and C's say around the sale of the NFT or the onward sale of the NFT via the NFT marketplace in terms of what rights does the token represent, what rights does the token issuer have, and what rights does the token hold again via the sale? Given that digital assets will be linked to the token, clearly IP is going to play an important role. So it's really important that there's clarity in terms of what the contract says around, are you buying a right to the IP in the digital asset linked to the NFT, or are you just getting a limited license to do something with that linked digital asset? Typically, in the music file example, where there's a unique URL in the NFT which takes you to a web server where you can download the music file, you're getting a limited right to download the file and listen to it for non-commercial purposes. What you're not getting is, you're not purchasing a right to own the music file. Copyright in that file is not being transferred to you, the token holder. Another issue is technical. What happens if the web server hosting the digital content goes down? If it goes down, then you click on the link embedded within the NFT and you're taken to a broken link. So the NFT is really worthless. So blockchain developers are looking at peer-to-peer file sharing or interplanetary file systems, or IPFS, where the content is distributed across a collection of nodes. So if one node goes down, the content is still available to be clicked on and viewed via the link embedded within the NFT. And then finally, there are reputational issues. In a lot of the examples of NFT commercialization that we come across with clients, it relates to brands wanting to license some of their IP, copyrighted music files or sports highlights, to a sophisticated technology company, let's call them the blockchain operator. And then it's for the blockchain operator to spin up and create the NFT and also create the associated marketplace and then sell the tokens. And in consideration of the brand providing the license to the IP for the content embedded within the NFT, they get a cut of the sale of each token. Now, that all sounds great, and the brand is outsourcing some of the risk here to the blockchain operator, but it's really important it protects itself in terms of doing appropriate DD on the blockchain operator. So is that blockchain operator an entity that can actually provide a resilient platform that's always available? Because if the platform goes down and people can't buy or sell their tokens, that will have a knock-on impact on the brand. And also, can it do that in a way which is compliant with local laws in every jurisdiction where the tokens are sold? That's a really important thing to think about, and that will come down to the nitty-gritty of reviewing the T's and C's with the blockchain operator.
There is not a harmonised regulatory framework for digital tokens, and this extends to NFTs. Whether an NFT is a type of financial instrument, such as a security, will depend on the characteristics of the NFT and the rights given to an NFT holder. The non-fungible character of the token does not affect its regulatory status. If the NFT merely represents an ownership in the asset or copy, this is unlikely to be viewed as a security, because all we're doing is conferring the ability to hold the asset and to buy and sell it. However, if the NFT has characteristics that are similar to a security, such as a share or a unit in a collective investment scheme, it could be considered as a security token. This could, for example, include fractionalized NFTs. If the NFT functions similar to e-money, then it could be considered to be an e-money token. There is a need to think about these regulatory issues, because if a person or entity carries on business in this area, they will need to be licensed in the same way as traditional financial services providers. For example, they may need to comply with licensing or AML requirements, and these requirements also apply to exchanges that are facilitating the buying and selling of these tokens. It also applies to wallet or custodians of NFTs. Those brands or organisations that partner with blockchain operators also need to consider regulatory issues, because there will be aiding and abetting laws in some countries, and also reputational issues relating to breaching local financial services laws. People have been discussing whether NFTs are a fad. In our view, in the digital age, there are more digital data to be created, and it is an opportunity for brands and organisations to drive their engagement with consumers. There are also clearly opportunities in the financial services sector with the way that rights to financial instruments or assets are held, stored, and distributed. Most NFTs that we are seeing in the market, such as in sports, art, and music, are unlikely to hit the regulatory parameters that I've just been speaking about, but use cases are expanding very quickly. If you have any further questions or would like to contact us, please feel free to reach out to myself or Johnny. Thanks.